Andrew, thank you so much for being willing to talk with me today about a very timely topic for trial lawyers, and that is the non-lawyer ownership or non-lawyer investment in law firms. And I'm not even sure if that's the proper way to refer to it, because I also hear people say public ownership of law firms or ABS structure, the alternative business structure. But you're the expert, so can you please help frame this conversation for us?
Sure, I'm happy to discuss it. It is simply a matter of opening up the opportunities for lawyers to obtain alternative sources of financing for their legal practices. Right now, we are restricted to only traditional forms of financing through loans from banks. There's an entire other structure that every other corporation generally is entitled to obtain, which is equity ownership or equity investment, which is the in consideration for a capital investment in an organization, the return is a portion of the profits in the most simplistic explanation. And attorneys are prohibited from obtaining such capital to help grow their business. And we brought an action to challenge that for several reasons. And I think it's, first and foremost, unconstitutional. And that prohibition on attorneys' ability to finance their practices and to grow their businesses should be no different than any other company or business.
And can you tell me about that case? Because I'm not actually clear. Is it going to the Supreme Court of New York, or where's that going to be determined?
Well, we commenced 3 different lawsuits, all in federal district court. One in New York Federal District Court, Southern District, one in the Federal District Court of New Jersey, and one in the Federal District Court of Connecticut. The actions in New Jersey have been stayed pending the outcome of the New York action, and Connecticut has not formally announced that's what they're doing, but through basically inaction, that's what they're doing. So the court that will be resolving our action is the New York Federal District Court. We started our action in 2011 in front of Judge Kaplan. We commenced our action initially against the Attorney General who would enforce the prohibition. The Attorney General appeared, made a motion to dismiss our complaint for a host of different reasons, and Judge Kaplan granted the dismissal based on procedural issues. I won't go into all the specific details, but to give a general overview. We appealed that to the Court of Appeals, and the Court of Appeals agreed that the procedural deficiencies did not warrant. Frankly, I didn't think there were any procedural deficiencies, and that whatever were raised, that didn't warrant a dismissal, and we should have been left with an opportunity to replead, which they remanded it, and we repled, and now the action is back before Judge Kaplan. We have our complaint is filed, the answer is in, they've made their motion to dismiss, we've replied, and we're now simply waiting for a decision from Judge Kaplan. So now it's in the district court. Pretty certain whichever side loses will be appealing, and will be going back to the Court of Appeals, and then whoever loses there will likely seek leave to the U.S. Supreme Court. So We're a few steps away from getting to the U.S. Supreme Court. And we don't know if the U.S. Supreme Court will take it, but that's likely procedurally what will occur.
Wow, that's really neat. The Australian, now you know this better than I do, but in doing my research, the Australian firm of Slater and Gordon opened their doors in 2007 to this ABS structure. Can you tell us a little bit about what has changed, or maybe even modernized in their delivery of legal services?
Well, Slater Gordon isn't really ABS. Slater Gordon, what they in the Australia legal market, they allowed, with appropriate restrictions and controls, they allowed for law firms to obtain capital through the equity markets. That is, sell a portion of the firm and bring in capital and then deploy that capital in a way to grow their business. So that's what Slater Gordon did. They sold a portion of their the practice to the public. The people owned shares in the law firm. The law firm then used that capital to purchase other law firms and roll up other law firms, and they are the largest provider, I believe, of legal services in the personal injury field in Australia.
Okay. You know what? I read something interesting because I'm not a lawyer. I'm a business person. But I read something that was interesting, and if I could, let me read it to you. It was about non-lawyer equity ownership by Brett Novak. This was April 7th, 2013, in the University of Michigan Journal of Law Reform. And here's what he says. Model Rule of Professional Conduct provides that a lawyer shall not practice with or in the form of a professional corporation or association authorized to practice law for a profit if a non-lawyer owns any interest therein. Thus, lawyers are not allowed to work for a LLC or LLP that practices law in a non-lawyer if a non-lawyer has an equity interest in the organization. The main ethical concern motivating this rule, and by the way, I hear this a lot, is that non-lawyer funding of law firms may lead attorneys to place the financial concerns of outside investors ahead of client interest. However, and this is the important point of this article, however, decision-making in law firms is already driven by financial considerations as attorneys seek to maximize profits and constantly increase metrics such as profits per partner. Well, I'm a business person, and that's almost a little offensive to me in some ways, because to me as a business person, it's almost like, wait, don't you think I have a moral compass? Of course. I mean, it's not just lawyers that can make these good decisions. So for me, that I hear a lot of lawyers talking about this is, it's not going to be good if corporations make the decisions, and I do think there's some validity to that. But I certainly think that we all, as business owners, have a responsibility to seek the best bottom line in financial decisions. So I'm sure you've heard that argument that this is going to be a bad thing for the industry. And what is your response to that? What are the positives that you see?
Well, you've thrown a lot out at that, and I have to separate it in a few different, I'll call them silos. One is the decision-making within law firms that currently exist. I wholeheartedly agree with what the article says, that in any law firm, decisions are economically based as to whether or not to take on a client, and once to take on a client, what to charge that client, and our duty and obligation of loyalty to a client includes informing them of strategic decisions on their case and whether or not that makes economical sense to take one course of action versus another. So the thought that lawyers don't currently engage in strategic decisions that are economically based and don't do it, and they do it in a vacuum, is just ridiculous. But that is the easy component of it. What in a different silo, and what is the underpinning and the suggestion is that lawyers who have taken an oath and are controlled by the ethical boards of whichever state they're in will somehow lose their moral compass because their employer is not another lawyer but is now a corporate entity. And to me, that is offensive. That lawyers, first and foremost, have a duty to their individual client, and the simple structure of the organization that they work for does not suddenly taint and poison an attorney from doing their and carrying out their ethical duty to their client. So those who are the detractors to this want to take a blunt instrument and suggest that everybody is incapable of exercising their independent judgment, which is what they're obligated to do, because now suddenly their employer is not a lawyer but a non-lawyer. It is absolutely ridiculous. There are plenty of regulations that can be put in place successfully. That's what's happened in Australia. They have certain requirements that if a law firm is going to have ownership that is by a non-lawyer, there must be certain committees and decision-making processes. What is the access to confidential information? Solely because somebody has an equity ownership in an entity doesn't mean that they have full access to all information. I own shares in Apple computers. I don't now all of a sudden have access to confidential information within what's going on with that company or corporation. We can easily, and there's a clear example of this being done in Australia, set up regulations as to what equity ownership in a professional organization actually means, what you have access to, and as long as there's full disclosure on both sides, that being the law firm and the investor, as to what controls that they may have or may not have, what access to information they may have or may not have, and how much management oversight they may have or may not have, all of these frankly, nitpicking, archaic concerns go away. And we have a clear example of them going away if we simply follow what's happened in Australia. There are plenty of alternative approaches to minimize the risks and concerns through appropriate regulation. And rather than ban all forms of equity investment, we should attack it with a scalpel and see what the biggest concerns are, make sure we have controls in place, and move forward. But the easy solution is just to say, well, it's never been done before, so we have to keep it this way, and be a fearmonger and say the world is the sky is falling because all lawyers will now become corrupt. I don't accept that. So that's my comment with respect to the ethical rules, and that's frankly exactly what we're challenging.
Right.
And that is the position that the Attorney General is taking. I think I personally think it has no merit.
I talked recently with Professor David Wilkins of Harvard Law School, and he talks about the globalization and modernization of the legal industry, and he specifically mentioned the way that the medical market had done that, and then he comparatively spoke about LegalZoom and other such platforms. You, I believe, are now. Do you have online legal forums, or I believe you're competing in that space as well?
Right.
And is that part of the master plan? Let me just say this: to me, you're really pioneering the next generation of legal services in the U.S., and of course, I applaud that because I think modernization is a good thing. And but I'm wondering with platforms like that, the other concern is, could it lead to further commoditization? How do you kind of reconcile that so that we don't have a lesser value of legal services?
Why do you suggest commoditization is a lesser value of legal services? There are certain things that are absolutely appropriate to be commoditized. Not everything requires a gray hair lawyer to be looking at certain aspects. That's the very core problem of what the legal industry faces. They attack every problem the same way, which is generally on an hourly basis or a set fee or whatever it may be, without actually looking at the root problem of it. And this is where expertise outside of the legal industry, if they had a capital interest in the legal industry, would absolutely solve these problems. As a perfect example, there is no doubt if Amazon or Apple Computers or one of these new age corporations who are accustomed to handling large volume of information in a systemized, organized way, attacked traditional problems that consumers have, they would come up with far better solutions in a far cost-effective way. And the economics would be one of far better for the consumer, because what we're really faced with and why this action was commenced is because the consumer there's a tremendous unmet legal needs in the U.S. economy and U.S. consumers. More consumers need legal services. New York State recently did a study that showed 95% of New Yorkers need legal services but can't afford them. And these are not indigent or poor people. It's the middle income people, because we have not attacked the delivery of services. If we attack the delivery of services in an efficient and economical way, we'll be able to deliver better services to a larger group of people in a more cost-effective way. Very similar to the corporate practice of medicine.
Yeah.
The medicine used to be delivered by individual doctors and individual practices, and then ultimately doctors joined practices together. But where the real value came wasn't just by doctors joining practices together. It was the delivery of the entire medical system as a complex organization, so that put together were the physician practices with in a larger healthcare system that are then connected with hospitals and throughout multiple markets, and they're then able to design plans that assist different people in a very coordinated and economical way, and ultimately resulted in profitable organizations delivering better services to more people at lesser prices. It's happened. So how it can happen in the medical field and not in the legal field is beyond me, because frankly, although law is very important, I don't think there's anything more important than one's health. And if they're worried about the corporation controlling a doctor's decision on the delivery of medical services, that hasn't happened. That was the big fear. That's what everybody concerned. But doctors still have their independent judgment, and they have what has been put in place are appropriate protocols for various treatments, because what was found in the medical field was a tremendous amount of waste, that there were duplications that were going on in the delivery of medical services and healthcare services. There were unnecessary procedures that were being done, unnecessary testing. And when you take all of that waste out of the marketplace, you take a lot of the costs out, but you still deliver high-quality services. It's no different than in the legal field. There's a tremendous amount of waste. The multiplicity of offices, the multiplicity of back rooms, the constant research by solo practitioners on the same issue. If there's a standard protocol for appropriate legal needs, the cost of those services will go all the way down.
That is tremendously valuable insight, and that's exactly why I wanted to talk with you, because I don't think anybody seems to understand all of this, and really that was so articulate, and I thank you for that commentary there. But let me ask you one more thing, if I could. So a lot of our readers, or most of them, are small to mid-sized law firms, and what I've heard a lot of them talk about is a fear. There's fear that they won't be able to compete. Some of them are preparing to sell their law firms, make them attractive for sale. What recommendations can you give to the small to mid-sized law firm?
It's not a recommendation. It's just to see what is happening in the industry and to recognize that there are great opportunities. I wouldn't look at it fearfully at all. It's in fact the exact opposite. That if you're now able to tap into the unmet existing demand for legal services by being able to deliver more services to more people in a very effective and efficient way, that should be welcomed, not feared. And that's really what I foresee happening. Now, will people be able to do it individually? That I don't know. Is that the most efficient and economical way to deliver legal services? Certainly not. So there, like everything else, there will be people who make individual judgments as to whether they feel it's professionally wise for them to engage in delivering services in a broad organization, a large organization that will allow them to do it very efficiently and effectively, or they go it alone. But it's been going on already. To suggest it hasn't been going on, all you have to do is look around. In almost any legal industry, you see smaller firms joining together, and there's a consolidation of law firms all the time.
Yeah, and would I'm just throwing this out, but would you have any interest in partnering with some of these firms as you grow Jacoby and Meyers to a even larger level?
That's exactly what I plan on doing.
Okay.
That's what I hope to do.
So here's my question. Can we, is there a way, or maybe you can tell me and we can put it in the article, is there a way that a law firm could apply to be one of your representatives in local markets? Or is that how, I don't know what your vision is, but...
That's exactly what my vision is.
Okay, well that's, okay.
There is a way.
Okay.
It is probably 3 months away.
Okay.
So it's a little just premature now, but certainly could just send me an email of inquiry, and I'm happy to start that process.
Okay. Well, what we'll do is that if anyone has, I'll put something in the article so that they have a method to reply, and then we'll get replies to you if people would like to talk with you. Because really what you're doing is, and again, I have such admiration for your brilliant mind, and that you're able to, you really are a pioneer with this, Andrew. You're the first, and I think it's going to be interesting to watch what happens. But as I said, when I talked to Professor Wilkins at Harvard Law, he really foreshadowed this all. And when he taught, I mean, not that he was the first one, but he talked so much about the need for the modernization of the legal industry, and that it is coming, and that it should be an exciting thing, not something to fear, because in the end, everyone will be served better, and with more efficiency and the modernization that comes along with it, it's going to make the law firms more profitable too, because a lot of law firms are struggling today. The small law firms, they're struggling. So, well, listen, thanks so much for your time. I really appreciate it.
My pleasure.